Good afternoon, everybody, and welcome to this exciting and very timely Brennan Center live event. For those of you who don't know, the Brennan Center for Justice at NYU School of Law is a nonpartisan law and policy institute. We work to strengthen, to reform, and when necessary, to defend the systems of democracy and justice in this country so they work for all Americans. And we are delighted to be here with you on this beautiful day in New York for this important conversation. I am Michael Waldman. I'm the president and CEO of the Brennan Center. Before we get started, before we hear from our colleagues and our expert guests, I want to share a few housekeeping notes. First of all, it's important to stress in this highly political season on this controversial topic, the Brennan Center is a nonpartisan organization, and we do not and cannot support any candidate or party for office, but we can and will vigorously debate the policies and positions that matter for our time, including those that are in the middle of public debate. Civility is very important to all of us. So those who post rude or intemperate language in our message streams here on YouTube and Facebook will be removed from the conversation. That is content moderation at its finest. Live closed captioning will be provided. And finally, you can follow along with the conversation on social media with the hashtag Brennan Center Live. And now to today's program. It goes without saying, the Supreme Court of the United States is an extraordinarily important institution in our lives, in our system of government, and in how we understand the Constitution. The Supreme Court is a singular institution. It has vast power and minimal accountability. It makes decisions that go well beyond nuts and bolts of rule of law to go to deep social policy questions, deep political questions for our whole country. And it is a subject of considerable controversy at all times, and especially right now. The court's credibility, the trust in the court by all public polls has plunged to the lowest level ever recorded. There's considerable backlash to specific decisions like the Dobbs case, which repealed the guarantee of reproductive freedom for women that had been in place since Roe v. Wade a half a century ago. There's considerable attention to ethics controversies and scandals that further rattle public confidence. And there is a growing political conversation and indeed a backlash. That conversation is not limited alone to the specific decisions that people are concerned about. Decisions just most recently, like the one that expressed the view that there was vast immunity from criminal prosecution for presidents of the United States in the Trump versus United States decision. That controversy extends now to the Supreme Court itself, to its conduct, to its role. And as I said, it is an institution by its very nature, with lifetime terms, unelected, that is often immune from accountability, and that accountability moment is now. In a lot of ways, there is a national consensus, interestingly, for action that stretches across party and ideological lines, and we'll explore the nature of that. I had the privilege of serving as a member of the Presidential Commission on the Supreme Court of the United States a couple of years ago. We're going to hear more about that in a minute. And it was striking, with all the different views that people had on the commission, with all the different views that the people who testified, and we heard from dozens of public witnesses, that so many people understood that this is an institution, a public institution, that is appropriate for conversation and ripe for reform. And so that is what we're going to talk about today. And once again, as I think it should be, but we can discuss that, the nature, the role of the Supreme Court is at the center of public debate in an election year and going forward. This conversation is part of a significant investment of effort, time, and resources by the Brennan Center in the work of Supreme Court reform. Our newly launched Kohlberg Center for the Supreme Court is going to help us bring substantive depth to this conversation, to this issue and this topic. We're thrilled to host this conversation as part of the first work of the Kohlberg Center. And we have three leading voices, three experts, three people who have in different ways participated in the life of the law to help us understand the ins and outs and why Supreme Court reform of one kind or another makes sense. First of all, we're honored to have with us Judge Diane Wood. She is a senior judge on the United States Court of Appeals for the Seventh Circuit. She is the director of the American Law Institute and a senior lecturer at the University of Chicago Law School. Today, it's worth stressing she appears in her personal capacity and is not speaking on behalf of any of those institutions. Christina Rodriguez is Leighton Homer Serbeck Professor of Law at Yale Law School. Christina served as the co-chair of the Presidential Commission on the Supreme Court and helped lead the 36 scholars and experts to produce an important product there, and has much to say. And Alicia Bannon, my colleague at the Brennan Center, is the director of the Judiciary Program here at the Brennan Center. She's the editor-in-chief of the State Court Report, which is part of our effort not only to look at the U.S. Constitution in a variety of ways, but at state courts and state constitutions and the independent and important role that they play. So I want to thank all of you for being here. And I want to start with some table setting. Why do we care about the Supreme Court? What role should it play? Why is it important that we have a strong and an independent Supreme Court in our constitutional system? And what has gone wrong in your view? And I will start with you, Christina, because of course you had the chance to chair this highly unusual and, in some ways edgy commission looking at the Supreme Court. How did you come out of that experience? What did you learn about your own views about the court from that?
I think that diagnosing what's gone wrong is in some ways easier than articulating what the Supreme Court is supposed to do or be. And I learned a lot in the process of listening to people from across the ideological spectrum, many of whom were scholars, also some of whom were in the thick of litigation, about what the problem might be with the Supreme Court as it stands today. And I think that even though there are many diagnoses, fundamentally, the calls for court reform stem from alarm at what the conservative supermajority on the court has been doing to and with the law, and the sense that their power is way out of proportion to the outcomes of the political process over the last several decades. So whereas President Trump appointed 3 people to the court in 4 years, Presidents Obama and Clinton appointed only 2 each in their 8-year terms, and President Carter appointed no justices. Implicit in this view, and I think almost everyone on the commission would have agreed with this, is that the justices are not just neutral arbiters of the law. And what they do matters, as you've already expressed, fundamentally to Americans. And the mismatch between who is running the court and the outcomes of elections is one that's led to dissatisfaction with how the court's functioning. That has been exacerbated by the sense that the Republican Party in particular has violated norms in the nominations process over the last several years, refusing to even meet with President Obama's replacement for Justice Scalia and rushing through President Trump's replacement for Justice Ginsburg. The debates that we had over what to do about this phenomenon and whether this phenomenon was actually a source of concern show that there's a great deal of disagreement, both diagnosis and solution, but it's clearly a matter of central importance because of the role that you've already expressed that the court plays in our system of government.
You're muted.
Not a metaphor, I promise. Thank you. We heard from dozens of witnesses. As you know, we were instructed at the outset not to reach conclusions by the executive order that established the commission. But there were dozens and dozens of public witnesses, and it was so striking how across the ideological lines there was a sense of something needing to be done, that something was out of whack, and that in one sense the country kind of was moving in one direction and the court was moving rapidly in another direction, and that over time can create a real crisis of legitimacy. Judge Wood, you've been on the bench yourself for so many years, as well as being a scholar of the Constitution and the law. You have a unique perspective on this. As you look at what we want from a Supreme Court and what has gone wrong, how do you see it?
Well, thank you, Michael. I think I'd like to pick up on one point that Christina was making, but maybe from a more fundamental level. We have courts as a third branch of government. We have two political branches of government. We have the Congress, Article 1, we have the executive branch, Article 2, and the people who wrote the Constitution wanted these neutral arbiters. You think of what it meant to be a judge way back in the latter part of the 18th century, and people still want that. They want there to be a difference between policy and law. And we can all debate what that difference is for quite a while, but I can say as a sitting appellate judge, it was critically important. Was I trying to craft a decision just because I thought it ought to turn out that way? Or was there some bigger force at work, some constitutional principles, some principle of a statute that was guiding not just me, but my colleagues, whether it was 2 other colleagues on a panel or whether it was 10 other colleagues on the en-banc court? And we're losing that confidence. If the only thing the court is one more committee of the Senate or something like that, one more political committee, we don't really need one more political committee. We've got plenty of them. But we need something in some way to assure people that it is actually legal principles that are driving these decisions. One thing I always would say, and we all know this to be true, when any court, certainly the Supreme Court, decides a case, the losing party needs to feel that it got a fair hearing, that there was some objectivity to the way the decision was made. And I do think people are losing that confidence. And I'll make another sort of side point, which is just to say that the court we have now is different from what they've had in the early decades of the Supreme Court, because of wonderful advances actually in medicine and in other things. People stay there forever. And I remember well talking to my son at one point, who's a lawyer, who said to me, Mom, you didn't even do e-discovery, which was true. I mean, you can get out of date. And the court structurally that's another way in which it's deviated from the population at large, one which has nothing to do with how many Democrats or Republicans or the like. It's just a structural flaw.
And it is an interesting fact when you look at the early days. On the one hand, they did understand that even at the time of the founding that there was judicial review, but they gave the federal courts and the Supreme Court in the Constitution only 10% of the text that they devoted to Congress and the presidency. The Supreme Court only achieved its role in our system over the years by maintaining and winning and maintaining public legitimacy to do what it does. And so it's an asset that needs to always be conserved by them, or it can be squandered easily. One of the reasons we're having this conversation right now is, of course, that President Biden, after not previously being warm to the idea, put forward some pretty bold reforms as a proposal for the Supreme Court several weeks ago, and really not only thrust this issue into the mainstream of public debate, and Vice President Harris, who of course is the Democratic nominee, embraced and endorsed what he was doing, but also I think in a lot of ways kind of normalized it as part of the political discourse. And one of the reforms, what I would say is the most important reform of all of these, is an 18-year term limit for justices of the Supreme Court. And Alicia, you have written about this extensively. We work on this considerably. Could you tell us how the idea would work, and what benefits you see that it would bring to the system?
Absolutely. So there's a couple of components to how a Supreme Court term limit system would work. So first off, you would have the justices' service on the bench divided into two phases. So the first phase, typically 18 years in the proposals, would be essentially the service as they have it right now. But then you would have a second phase of service where the justices' duties would change. So they would still be judges, they would still get paid, they would still hold their offices, but the duties of that senior Supreme Court justice would be different. The details vary depending on the proposal, but typically those duties would include things like serving on the lower courts and often hearing a limited number of cases on the US Supreme Court, but not the full appellate docket that the justices, the active justices would be hearing. The other component of the 18-year terms, which is sometimes overlooked, but I think is in some ways even more important, is that there's also a regularized appointment process. So mathematically, if you have 9 justices and 18-year terms, it means that you can have regular appointments where every 2 years a new vacancy would open on the court. And so that means every president in a 4-year term would get 2 and only 2 nominations and opportunities to put new justices on the court. And so together, what does that do? It responds to, I think, many of the concerns that Christina and Judge Wood were raising in their remarks. So, one, it restores us much closer to historical norms in terms of how long justices were sitting on the bench. So justices today sit more than a decade longer than they did as recently as the 1960s on average. It also creates a dynamic where the court is more closely linked to the public because presidents would have equal opportunities in a 4-year term to influence the trajectory of the court, to have an impact on who's sitting on the bench. And it also aligns us with kind of global norms. So the United States is the only major democracy in the world that has life tenure for its judges. And so, I think there's a lot to commend a term limit system, and it addresses many of the challenges that we're seeing in this current moment.
One of the ideas behind having the regular appointments combined with term limits is that it would drain some of the toxicity, at least that's the hope, from the confirmation process and the nominations process, because so much of what ails the court right now happens before anybody puts on a robe, and the politicization of it and how enmeshed it has become in the Federalist Society as a political machine and all the other ways in which politics has enclouded the court. To me, the basic premise of term limits is that nobody should have that much public power for too long. And it's a notion that George Washington taught us when he limited himself to 2 terms. And of course, the Constitution itself was amended to make sure of that in a way that House members are not limited. There's an amount of power that is dangerous for anybody to hold for too long. Christina, the commission, it was really striking how much enthusiasm there was for this idea on the commission. I was a bit surprised, and I don't know if you were too, but if you could take us sort of inside the thinking of the commission, why do you think this in particular was an idea that had as much enthusiasm as it did, as opposed to some of the other ideas that people had about what to do about the court?
So as you've already said, we weren't asked to make recommendations. And so my co-chair and I did not attempt to discern whether there was a consensus on any issue, but you could detect different forms of disagreement about each of the proposals. So whereas with proposals to expand the size of the court or pack the court, there was extremely sharp, almost existential disagreement about whether it was a good idea, the disagreements that appeared about term limits seemed more like ordinary policy disagreements. And there was not the sense that a term limit would be the end of the Supreme Court as we know it. And I think there are a number of reasons why there is widespread support across the ideological spectrum for term limits, and why, despite the fact that some of our commissioners were opposed to term limits, it's something that many people found to be a reform worth considering. We've already enumerated some of them in this conversation. It would reduce the concentration of power in the hands of a single individual. The 18-year term would ensure the value of judicial independence, which is the purpose of the good behavior requirement in Article 3, by providing long fixed terms that extend beyond any single 4 or 8 year administration. But as Alicia said, it would better align the court's composition with the outcomes of the political process by ensuring that each president gets 2 nominations and hopefully confirmations for each 4-year term. And it would regularize something that now seems random and seems subject to strategic retirements or the luck of the draw. All of the risks that surfaced with respect to term limits during our discussion, such as what would justices do when they were required to end their term? Would they try to curry favor with people in power to get a plum government appointment? Would they seek favor with corporate clients in order to move on to success in the private sector? Are matters that really could be dealt with through a term limits proposal. They're not risks that in any way overshadow or outweigh the benefits. And at the end of the day, I think most people, if asked, would say if we were designing a constitution from scratch, we would never have justices on the Supreme Court serve for life. It's only the convention that we've held for this many years that allows that kind of a system to persist. And for all of those reasons, term limits seem like precisely the sort of good government reform that would make the Supreme Court better, that in at least in non-polarized times, lots of people can agree with.
Well, and as you know, all but one of the 50 state Supreme Courts have term limits or the effective term limit of a retirement age. And the constitutional courts of all the other major democracies do as well. And that has not hindered their effectiveness in their system. Judge Wood, that I want to follow up on something that Christina said about a value we care about, which is judicial independence. And you, of course, had and have a lifetime appointment on the federal bench. The purpose of that, in part, is to offer judicial independence. How do you see this issue, and why do you think this doesn't pose a challenge to judicial independence?
Sure, thank you. I do not see this as posing a big challenge to judicial independence, partly because 18 years is a long time, and I can look at what's happened to many other Article 3 judges, some of whom more district judges probably than Court of Appeals judges, but they go on and they have second careers in mediation or arbitration. I can think of judges I know from apex Supreme Courts in other countries, and they have distinguished service, on UN panels, or they bring their experience to bear. The kind of person who's going to be a judge for 18 years, I think, is somebody who's already committed to public service and is not likely to say, I hope the firm of X and Y, gives me a huge salary. If that's what they want to do, they can leave after 2 years if they want to, and they'll still get it. I just don't think anything like that is likely to happen. And let me also actually insert that one of the details about many of these 18-year plans is that it's a term of years. And so if, for example, a justice tragically fell ill and died after 3 years in service, you don't get any longer term. The president at that time can just fill the remaining 15 years. So the possibility of strategic retirements is far less under this program or this idea than we have right now. So I think, again, there's one other point I would make, which is that the current system rewards the appointment of the youngest possible person who might qualify to be on the Supreme Court, people in their late 30s, people who are early 40s, and then they're going to be on the court for like 40 years. Whereas the 18-year term, it's just 18 years. And so maybe we'll go back to finding the very most qualified people. And if somebody at the age of 55 or 60 goes to the court and then leaves when they're in their early 70s, maybe they're happy to continue doing judicial work of these other kinds. And by the way, I will just insert that I wish we had some catchy phrase for work assignment limits, because it really isn't a term limit that we're talking about here. We are preserving the Article 3 status of these judges. We're preserving their right to decide cases. We're actually also preserving the fact that they have to comply with whatever ethical restrictions there are. And I know we'll talk about that later, but you are a judge in every meaningful sense of the term. And remember that right now, since it's optional, you'll have somebody like Justice Souter, who regularly sits on the Courts of Appeals. Justice O'Connor sat with the Seventh Circuit on a number of occasions. We were very happy to have her. And so they're Article 3 judges for real.
And that the point you make about the kind of longevity that justices have now and the type of tilt that provides to who gets appointed, as you all know, there was, for most of the country's history, we had attorneys general, we had governors and senators appointed in a way that we don't have now. And I had not thought actually that much about the interplay between this proposal and bringing some of that experience onto the bench. But Judge Wood, you sort of landed on a key question, which I'd like all of you to talk about. Term limits can be done by constitutional amendment. There's certainly no question about that. But what we're discussing and what at the Brennan Center we're encouraging is actually the reforms enacted by statute. And I think that is important for folks to understand how that is possible to do. I think it goes to this question of people remaining as federal judges with different roles. But why is it that the idea that the Constitution gives people lifetime terms, why is that wrong? And why is it something that in this way could be done by statute?
I mean, I would say the Constitution actually doesn't say lifetime terms. It says you serve during your good behavior. We'll assume everybody is engaged in good behavior. But let's go back. If we want to talk about history, let's talk about history. There is also in Article 3 a clause that allows Congress to make exceptions and regulations to the appellate work of the Supreme Court, as opposed to the court's original jurisdiction, where they're sorting out, whether Georgia and Alabama have water rights, for some river or something. So the Constitution itself gives Congress significant power to structure the appellate jurisdiction of the court. That's point one. Point two, when Congress first established the federal judiciary and chose to create both inferior courts, as they're called in the Constitution, and the Supreme Court, the justices rode circuit. It was entirely consistent with the title Justice of the Supreme Court to have you, out in Virginia hearing as a trial panel. Initially there were two Supreme Court justices and one lower court judge. Then they changed it to have one Supreme Court justice. And finally in 1891, they got rid of the whole system. But for a century, Congress assigned lower court work to Supreme Court justices, and it wasn't giving them the choice. It wasn't the option that we now have for senior things. So I would think people who think that we should be informed by history ought to take a page from history. And that page tells us that you can do this if you want to. It's within the power of Congress. And Congress has exercised its power over the Supreme Court's structural aspects, of course, not over case outcomes, but the number of justices has changed over the years. The way that we fill vacancies for the Chief Justice is governed by Congress. The fact that how we even choose the Chief Justice is governed by Congress. There are many things that Congress governs. And I'm not saying it wouldn't be a difficult political slog if somebody thought that there was some disadvantage to their side, but I frankly see no constitutional barrier. The only thing I thought is maybe there's some requirement to allow all people, both senior and active justices, to sit on the original cases. But other than that, I think that it's really a question that we can take up in Congress.
Christina, you have looked at, and Alicia, there are many cases, and there's considerable case law making clear that these kinds of jurisdiction changes and other things can be done and have been done. Many people say to me, well, but wouldn't the Supreme Court just strike down term limits done by a statute? How do you think about that?
So I think that is a very real risk, especially given today's Supreme Court. I also think that whether this can be done through constitutional amendment or through statute or requires a constitutional amendment is going to be a source of enormous controversy. And even though I think there was widespread support for term limits on our commission, there was deep disagreement about whether this is something that required a constitutional amendment. One of the things that I found myself changing my mind about was this very question. I was ultimately persuaded after actually diving into history, case law, structural considerations, that in fact, it would be permissible to enact a statute that produced term limits, but that the real source of concern was not the constitutional one, it was a pragmatic one. And I think it's important to be clear-eyed in thinking about adopting a system through statute. First and foremost, there is the role that the Senate plays under the Constitution in confirming the president's nominees. And if we continue in the politics of our moment, I think what you're likely to see is a Senate, when it's controlled by the party opposite the president, refusing to confirm nominees, which would undermine the regularization that we've been touting as a benefit of term limits. So that presents a real problem, and it's not clear to me, and I don't think the commission actually had a good answer to this problem, that you could address the Senate's role through a statute. And so that's something that is important, in addition to the risk that the Supreme Court would strike down a statute, to keep in mind, even though, as Judge Wood has ably explained, and as Alicia has done in her work, explained that it is not inconsistent with Article 3 to think that Congress could change the way that the justices sit and set their terms on the primary cases of the court for 18 years, as long as they retain their judicial office and perform these other functions that many other court judges in our system also perform.
And I am perhaps less worried about the risk that the Supreme Court would strike down term limits than others might be, in the following sense. If the public demanded term limits and Congress were to actually enact them, and the Supreme Court were to just strike them down, that would give enormous impetus to a constitutional amendment. It would be a form of constitutional crisis on its own, but there is a long history of a back and forth between the court and the public, the court and Congress, over the years, leading to constitutional change and constitutional amendments. And I think that there would be real risks to the Supreme Court if they were to do that. It would look very self-interested, at the very least. Let's quickly turn to the other big reform that President Biden endorsed, that is also something that is being discussed on Capitol Hill and in the court itself, which is ethics reform. Alicia, as you know, there have been in recent years significant public controversies around the ethics of Supreme Court justices, the revelations that one activist, right-wing billionaire, Harlan Crow, has basically subsidized the lifestyle of Justice Thomas for decades. He used to disclose it. Then the Los Angeles Times in 2002 reported on it, so then he just stopped disclosing it. And even buying his mother's house while she was living in it, and all kinds of other rather lurid things. The Supreme Court put forward last year a code of conduct. In its statement, it said this was merely to clear up the, quote, misunderstanding by the public. Up until that point, the Supreme Court was the only federal court that did not have a binding code of conduct, a binding ethics rule. The question I have for you is, what's wrong with what the Supreme Court did? What's missing from what the Supreme Court did? And can Congress, in fact, act on this?
Absolutely. So, I mean, so first off, just stepping back, the public confidence in the Supreme Court right now is hovering at record lows. There was a recent poll that found that more than 80% of voters think that the court is behaving in a partisan manner in its decision-making processes. So we're at a real crisis moment in terms of the Supreme Court's legitimacy. And I think that has to, be sort of in the background as we're thinking about ethics issues. So in terms of the U.S. Supreme Court's code of conduct, it did adopt a code of conduct, but without any kind of enforcement mechanisms. And so, basically, if a justice fails to abide by the code of conduct, there's both no process by which somebody can raise a complaint. There's no transparent process, at least, by which the justice's conduct can be assessed. Did they, in fact, comply with the code of conduct or not? And then there are no consequences if in fact, a justice fails to comply with the code of conduct. And in fact, Justice Kagan just recently spoke about this and said, look, it is a legitimate concern. Typically, when you put in place rules, there has to be some mechanism to enforce those rules. And so what President Biden called for in his call to action, and we've seen a lot of different legislative proposals as well, would be some mechanism by which people can, where complaints can be filed and there can be a public adjudication of potential violations of the code of conduct. And is that within Congress's power? I would say absolutely. I don't even think this is a close case. Congress has clear power, and it has exercised that power over the centuries in many ways in terms of regulating the Supreme Court and the lower courts as well with respect to ethical questions. Currently, there are statutes that require justices' recusal in certain situations, that require certain financial disclosures. Now, is that enough? We're not necessarily seeing full abiding by those provisions, but certainly it is within Congress's power. And I would step back in terms of the why. It goes back to what I was saying and what Judge Wood was speaking about earlier, which is that ultimately, the courts, they don't have the power of the purse. They don't have a sword. What they have is their legitimacy. That's the basis of the court's ability to perform its necessary role in our democracy. And so it's absolutely within Congress's power to put in place safeguards such that the court, the public can be confident that the court is able to hear cases in a fair and unbiased manner.
Thank you. So I want to turn to some of the questions we're getting from the folks who are watching us. The first one really is about the politics of this. Term limits in particular, and ethics reform as well, are widely popular with the public. A recent Fox News poll showed that 78% of the public, for example, supported an 18-year term limit for the Supreme Court. And that, of course, includes many Republicans, a significant majority of Republicans, as well as independents and Democrats. There are very few public issues with that kind of national consensus. And the idea of Supreme Court term limits have been supported over the years by John Roberts, by the founder of the Federalist Society, Stephen Calabresi, and many others. But nobody's under any illusion. This is a question from the audience. Nobody's under any illusion that when it actually starts to move in Congress, that kind of group hug will be what transpires. How does this not look partisan? How does this not become just mired in controversy? In other words, we know that Congress always has been partisan in its divisions. How do we translate the broad bipartisan, nonpartisan support for this into this actual political system? Christina, you've thought about that? Certainly,
it's a hard question to answer because I think it is hard to imagine legislation or a proposed constitutional amendment, for that matter, working its way through this Congress without becoming politicized. And you already see in the criticisms that are circulating in the public of term limits as well as of ethics reform, the view that the proposal of both of those are ways of attacking the current Supreme Court, that term limits are a way of depriving what is now a conservative supermajority of the power that they have accumulated, and that the ethics reforms are targeted at dislike or distaste for Clarence Thomas and Samuel Alito in particular. And it's very hard to imagine members of Congress who ascribe to a party breaking out of that. But I do think the way to overcome that is to consistently make claims about both of these reforms that are about making the court better. And term limits and ethics both have very little to do with the outcomes of cases. They're about creating processes that ensure that in the case of term limits, you have a regularized system of appointments, and we don't know what the future holds in presidential elections. So the benefits will accrue over time to both political parties. And in the case of ethics, applying the same standards that apply not just to all lower court judges, but to people who work in corporations or people who work in areas where there could be potential conflicts of interest. And so it is not about targeting particular individuals, it's about the more general reform. And to the extent the advocacy can remove the support for the reforms from targeted attacks, it might help in the long term, even though the motivation for term limits in particular, as I said at the very outset, does have political orientation in today's moment.
Judge Wood, you, as a federal judge, have been and are subject to binding and tough ethics rules. What benefits has that brought to you in your service as a judge? In other words, from the judge's perspective, why is that a good idea?
Well, I'm going to say, actually, by preface, that I've seen this from both angles, from the angle of a judge who was subject to these rules, and also during the nearly 7 years I was chief judge of the Seventh Circuit, I was the local administrator of these rules. All ethics complaints come first to the chief judge, who screens them, and then there are further procedures that we could talk about if you want. But from my own point of view, it gives you legitimacy. You know, I had a public list of every company that I or my husband had so much as one share of stock in. Anybody could look at that list. I checked it. My assistant checked it. I knew what was out there. The financial disclosure forms that federal judges have to file once a year, the form AO10 is what it's called, also help protect the appearance of conformity with the rules. There's within broad ranges, any member of the public can see exactly how much money we have. I mean, just assets, how much income they throw off, other sources of income, which are actually quite strictly restricted for active federal judges. It's 15% of the executive level 2 salary, which winds up to be about $30,000 a year. That's it. That's all you can get from teaching, say, at a law school. But the main thing is it's transparent. The public can see it. I'm not living in some house that I could never afford in a million years. And I just wanted to go back to a point that Alicia mentions, very, very important point. Congress has regulated this sort of thing for all judges, including the justices, by statute for years. What the justices haven't done and what no one else has done is put them under this more detailed code of conduct that ensures that federal judges are not using the office for any kind of profit, not so much as writing a blurb on the back of a book because it might look like you're almost selling the office. And since we have nothing but the persuasiveness of our opinions, we need to be above reproach. And so I think every judge I know, no, it's no one's favorite time of year, but you fill out these financial forms and you have accountability, and that's very healthy for the system.
So one question, which I will take the prerogative of helping with the answer to, is why didn't the framers see this coming? In other words, given all the concerns that they had about unaccountable power, which was baked in so many ways into the Constitution, why did they set this system up in a way that could be subject to distortion or abuse? What I'll note is that there are many aspects of our constitutional system or our political system that were quaint Americana or acceptable distortions over the years. The Electoral College being one example, which followed the popular vote for well over a century until 2000, and of course has now given the person who lost the popular vote the presidency twice in the last 2 decades, and it almost happened 2 other times. John Kerry in 2004 almost won the presidency without winning the popular vote. The Senate, with its representation for each state, equal representation, which was very unpopular with founders like Madison and Hamilton. At that point, the biggest state was only 7 times bigger than the smallest state. Now California is, I can't ever keep it straight, but something like 70 times bigger than Wyoming. The filibuster, which is not in the Constitution, but is something that was once used sparingly and now is applied effectively to every ordinary piece of legislation in the Senate, and on and on. And one could argue that lifetime tenure as it's been implemented for the Supreme Court, for all the reasons we've been discussing, is something that needs to be revisited the same way these other things do, in the sense of entrenching minority political power or distortions to the system in a way that not only was not intended, but really hasn't been the case up until now. Are there other reforms that we haven't discussed that are worth looking at as well for the Supreme Court, having to do with jurisdiction or legislative responses or any of those other things? What do you all think about that? Alicia?
Sure, I can jump in with some. So I think absolutely there are other reforms we should be thinking about on the table. Ones that I'd highlight relate to the court's docket and its so-called shadow docket. So one recent trend we've seen is an increasing amount of activity and very high stakes, high profile cases showing up on what's known on the court's emergency docket, or what's sometimes called the shadow docket. So not what the court cases that the court's hearing in its ordinary course with ordinary briefing and argument in a very public way, but these fast-moving emergency motions that can often move very quickly without a lot of briefing. The court's decisions often don't have any reasoning associated with them, or just very little reasoning, often inconsistent application of what the standard should be for considering these kinds of emergency motions. And they can have a huge stake for the litigants that are appearing before the court. And so, as that shadow docket has become more significant, I think there's a lot to do to think about how can we respond to what might be seen as abuses of that emergency docket. And that can include everything from requiring more transparency around how the court is hearing cases on its shadow docket, moving certain things from the shadow docket to mandatory appeals. So for example, certain kinds of death penalty challenges, there's a lot of activity on the shadow docket. I think there's a strong argument that maybe some of those should just have automatic appeals to go straight to the Supreme Court, so they're not moving on that fast-moving shadow docket. There can also be potential opportunities to actually codify some of the standards that the court has been applying in terms of considering various emergency motions, but often applying inconsistently. So for Congress to step in and say, this is exactly the rules, these are exactly the steps that you, Supreme Court, should be taking. There's also reforms that would look to put more just on the court's docket overall. Another thing that's very different right now from the court in the past is just it's hearing fewer cases. The number of cases on the merits that the court's hearing is the lowest since I believe the Civil War. And so the court actually is not doing that much overall. It's kind of cherry picking some very high stakes cases and not actually resolving a lot of legal disputes where they would benefit from having the country's highest court weigh in. So another set of reforms would be to put more things actually back on the court's docket and maybe create opportunities for appellate courts to certify cases to the U.S. Supreme Court, or look at other ways that we might increase the mandatory jurisdiction of the Supreme Court.
Do you think that there is a meaningful distinction? How important is it? One of the questions in creating a term limits proposal is, do you apply it to current justices, which have some pluses and minuses, or do you make it prospective only, which have other pluses and minuses? Do you all have views on which of those makes the most sense?
Well, I can say a group that I worked with through the American Academy of Arts and Sciences took a middle position between those two. The sense, and I think I'll go back to something Christina said, to apply it to the sitting 9 justices who all took office under a certain understanding of what the role was going to be, would at the very least probably be very unpopular with them, even if at some raw power level it were possible to do that. The problem with just letting it happen through natural attrition is that studies have shown it would take 50 years to come into effect, very likely, or something close to 50 years. So the intermediate solution is to begin appointing on the 2 people per presidential term schedule, which I noticed a question. Over time, once it's fully implemented, that gives us a court of 9 people. And that's the size that we're comfortable with right now. So in order to do that, you would have to expand the size of the court temporarily, not in the court packing sense, but as people retire, it will shrink back to the ultimate 9. And that lowers the amount of time it would take for this to be fully implemented from 50 years down to 25, which I realize is not a minute, but it's better than 50. And it's a compromise position, understanding that the existing justices did have perhaps some expectations.
Flowing from that, for each of you or any of you who want to take it, one question we get and we've seen in the chat is, well, why not court expansion? Court expansion, as we know, is legal. It's been done before. 9 justices is not in the Constitution. As we know, President Franklin Roosevelt proposed expanding the court in 1937. Why is, in your view, that not the appropriate way to go, if that's the case?
Can I just say, at the lower court level, whenever Congress passes a bill expanding the number of district and court of appeals judges, there's always a political edge to that. Is some administration going to have a windfall of all these judicial appointments? And that isn't really the atmosphere that we're going for. So I think it is true that until just after the Civil War, we had the same number of justices as we had circuits. So you could right now just say, well, let's just do that. We'll have a circuit justice for each circuit. We'll have 13 justices by the time you have the 12 numbered circuits, 11 numbered circuits, the DC circuit and the federal circuit, that would be 13. And that feels much less political than the Franklin Roosevelt plan was. But that's the most I could imagine doing without really running into a political buzzsaw.
Go ahead.
Say, Michael, the concern, or one of the chief concerns, is doing something that's clearly legal and that Congress could clearly do through statute could lead to a retaliatory kind of arms race. And I do think it's worth injecting into this conversation a note of caution that trying to play with the structure of the courts in order to advance the interest of your political party is a strategy that is at the heart of democratic backsliding around the world. It is a way that political parties and strong men or strong people can gain control of the branch of government that's supposed to hold them to account. And so I do think it's important to be careful with strategies that are clearly partisan or can hardly be explained away as nonpartisan, and that once begun leads to the other side to try the same thing. In response to that, people who favor court expansion would say that eventually there will be resolution, that the tit for tat is a mistake, and that the only way to address what have been a consistent set of norm violations by one party today is to do something dramatic, and then that will eventually lead to some kind of a pullback from the brink. It's hard to predict which way this would go, and I do think that what has happened to courts in the hands of executives that want to entrench their power is worth noting as a point of caution.
And I say, as somebody who feels very strongly and have written books about this, I feel that this court has been captured by a faction of a faction in a way that is unprecedented in American history. It's also really important that any efforts to respond to that seem legitimate to the public. And you're exactly right that even Franklin Roosevelt, at the peak of his political power, having just won the biggest electoral landslide in American history, and with the Supreme Court about to strike down Social Security and the Wagner Act, the labor laws, and all the other parts of the Second New Deal, even he found that done wrong, Supreme Court reform could create its own ferocious backlash in a direction he didn't want. And we've seen that in other countries. We saw that in Israel, in the streets of Tel Aviv, in the response there, and in other countries as well, judicial changes. It's not something to be merely waved away by saying, well, that's not hardball. It's actually important to understand the politics of judicial reform. We have just a few minutes left, and I would like to ask each of you to give us a short answer of what would you hope that viewers and listeners take away from this conversation. What is one thing that you hope people remember? And I'll start with you, Christina.
I would say that the Supreme Court and individual justices today have too much power, but the Supreme Court is an incredibly important institution in our system of government, and there are ways to make it better if we can find the political will to do that.
Thank you. Judge Wood.
Yes, I would say very much the same thing, that the Supreme Court needs help now. And maybe even one should start at the more straightforward way it needs help, which is to have an enforceable ethics code. You could take the models that some of the state Supreme Courts have. You could take the model that the lower federal courts have. This is doable. It really is. And there's huge support for it. As far as the structure of the court is concerned, these are serious proposals. Some of them have been around since the 1980s. They really don't favor one side or the other side. And if people can come back to realizing that there are some things that are simply nonpartisan, that are good for us as a country, I hope they think that this kind of structural reform of the court is one of those things.
Thank you. Alicia Bannon.
What I'd say is just a reminder that nobody should have this much public power for a lifetime. The US is a global outlier. No other major democracy in the world has life tenure for its highest court. Nearly every state in the United States has either terms or age limits for their high court justices. So this is well established that that term limits are consistent with judicial independence and are a good policy that that Congress should take on.
And I will give my answer. We should not be afraid of Supreme Court reform as a political issue. We should celebrate it. I think Supreme Court reform is an issue whose time has come. There's tremendous public support and tremendous public concern about what has gone wrong. And if that means it gets caught up in the rough and tumble of politics, that's American history and that's the American way. Conservatives have campaigned against the Supreme Court, against what they call permissive liberal justices for decades, and that was appropriate. And when we hear people say, oh, don't politicize this issue, that's very often just a way of saying, be quiet. And I think it's important that we not be quiet. I think that it's important that we encourage people in all walks of life to speak out on the Supreme Court and the justices who should be appointed and what the system should look like in this campaign, in this election season, but going forward year in and year out. And to me, it is actually a very encouraging moment, entirely consistent with the way our country has righted the ship in years past. I want to thank our panelists. It's been incredibly interesting, and we've benefited so much from your expertise and your experience. I want to thank all of you for joining us. We look forward to seeing you at future events on this topic. Again, we at the Brennan Center, working with our new Kohlberg Center on the Supreme Court, will be having a lot to say about the Supreme Court. And if you want to be the first to know when these kinds of events are announced, please sign up at our newsletter for the events newsletter at brennancenter.org/events. Thank you all for joining us, and to be continued.